Good afternoon. It's great to be back at the Runnymede Society Conference this year, bigger and better than ever. I was looking forward to just sitting back and enjoying the panels this year, but Joanna asked me to moderate this discussion, and I felt like I couldn't say no. That's only partly because of how persuasive Joanna can be. I'm also really excited about this project. So why don't we start out, Scott, tell us a little bit about the Primary Documents project, because you have this book that's coming out of that project, but it's something bigger, as I understand it.
That's right. So the Primary Documents project is a project that seeks to overcome a problem that was, I think all of our legal community have felt when dealing with the Constitution, but particularly this has been articulated very well by one of our former Supreme Court justices who stated that it's very difficult to provide an accurate originalist interpretation, what the framers intended or what the reasonable participants at the time would have thought that the Constitution meant, because of the fact that there's a shortage of ready access to a complete historical record. And then this is former Justice Binney, and he said the danger when we try to cite extraneous materials is that we will cite non-representative materials, not realizing they're not representative because of the partial nature of the record. This means that we will have, in place of judge-made law, we will have judge-made history. The attempt, therefore, is to gather all relevant documents, primary documents from the period of the development of the 1867 Constitution, the 1982 Constitution, and all of the intervening subsidiary Constitution Acts, put them together online in a format that is searchable, hyperlinked, and available both in a format that lets you look at the original document, a PDF effectively, and also an HTML version that is conformable to whatever platform you're looking at it on.
Oh, that's a fascinating, important project. So you have a draft of a book that's coming out of this project. Perhaps you could tell us a little bit about what that is.
So yeah, what we're doing this year, we realized as we went through this process, and we've got now somewhere in the neighborhood of 1,600 documents, obviously tens of thousands of pages of documentation online, but the fact is that most of it is pretty obscure documentation, but there are a few constitutional documents that are constantly referred to by our constitutional scholars and yet are not readily accessible. And the most obvious of these is the Confederation debates of 1865. These are the documents recording the debates of the Legislative Assembly and Legislative Council of the Province of Canada as they voted on a resolution and debated adopting a resolution to adopt the Quebec resolutions, which are the draft form of the what became the British North America Act. These documents were printed contemporaneously. It was felt to be important enough that a series of reporters were hired to write them down and publish them in 1865. So a reasonable member of the public, a publicly minded citizen, could acquire these, read them, make up his or her own mind as to the merits of the debates. Since that time, they have not been republished. So reference is made to them constantly, but it is not easy to actually get a copy of these documents. Any surviving editions are 150-odd years old and are in a limited number of libraries. However, it is possible to scan that material and reprint it, and that is what we've done. So we have I'll just hold this up, a 3-volume set containing the Confederation debates of 1865, which my colleagues and I have been putting together, correcting and turning into a usable form that includes, among other things, an index allowing you to search by subject matter or by speaker in order to have better access to what the framers actually meant.
And importantly, you were telling me yesterday, importantly for citation purposes, you have the original pagination, right? So you've kept the original pages so that you can cross-reference with the original.
That's right. Anybody who's actually attempting to quote the original debates ought to be able to do so as if the source they were looking at was the original document. There's an obvious problem. You're using a 19th century font and layout. They didn't believe in paragraphs in those days, so if Sir Johnny Macdonald gives a 3-hour speech, it is one giant 10, 15-page paragraph. We've tried to adjust for that. but at the same time to retain page notes allowing you, when you read the document, let's say for the sake of argument, you are reading in anticipation of taking an argument before the courts, you can with ease see the actual page from the original documentation and use and cite that page. As well, the print version guides you back to the online version. So if you want to actually go and see the original version from 1865, you can go online, and there it is on the Primary Documents website.
Scott, is there anything particularly interesting or surprising that you came across as part of this project in terms of reading through these debates or other sources?
In terms of these debates, one thing that struck me profoundly, of course, everybody knows who was at the last year's conference that I did a presentation on the Supreme Court's ruling on the Senate reference case, which I regard as a very problematic ruling. And I think it's problematic in large part because those who were advocating before the court and the members of the court itself did not have ready access to the relevant debates. So in that ruling, you see the famous phrase referring to the Senate as a chamber of sober second thought. It's referred to over a dozen times, but never with more than the sentence fragment, chamber of sober second thought, or sometimes chamber of sober second thought in legislation. Everybody knows that's Sir John A. quote. It's actually a quote from these debates, but if you try and find that quote online, anybody can do a Google search and you'll see what happens. You get thousands or tens of thousands of mentions, none of which gives you more than the sentence fragment, which means it's always decontextualized. So after we scanned it, I went and actually looked up, and it was easy to do on primary documents, that phrase, and got the whole sentence it comes from. And what you realize when you see it is Sir John A. Macdonald did not mean what everybody thinks he meant. Once you see the whole sentence, you realize he was not saying the chamber of second thought, in which serves merely a review capacity. He's very clear in his wording that what is meant is actually that the Senate will be the chamber in which legislation, which is typically initiated in the House of Commons, largely because the House of Commons initiates money bills, will be reviewed second in order chronologically. And that changes the whole tenor and suggests that these citations of the famous passage are quite literally misunderstanding what its intent was. Not because of, you can't blame the members of the court for this or those who are advocating before the court. It's genuinely hard to find this in a 900-page document unless you have it in some form that is searchable. Now, the book isn't searchable that way. We have a normal sort of index. But you can go online and simply type that in, bang, you get the phrase, can read it in a contextualized manner.
So how do you foresee this work being used? How do you, by lawyers and scholars?
Well, I mean, ideally you would create a situation, once you've got enough documentation up there, you can say that essentially the universe of documents that are still in existence in some form or another, old newspaper articles, pamphlets, and so on, that have not simply been lost entirely, that exist somewhere in some archive or library, when you can say with confidence that the vast majority of those are now up on the website, you can say that to the extent possible, we've answered Justice Binney's concern, that the dangers of accidentally taking some document or some statement as being representative when it's not has been reduced to the extent that is realistically possible. And therefore, when the court attempts to be originalist, as it did in the Senate reference case, and it does in other cases, that it is actually reflecting a real as opposed to a fictional history.
It's not just selective quotations. Yeah.
Yeah, that's right. And to be clear, I'm not suggesting that the quotations are being done selectively out of a desire to produce a fictional history. I think literally the reason only a part of that sentence was quoted was because that was all that was available to everybody in the court. But what's true with that citation is true over and over and over again. So we hope to overcome that. The reason for doing a paper version is simply that you can search this online. Online searching is still not as easy as a practical matter as taking something off a shelf in a library. And given the geographically centralized nature of the practice of law and of court rulings, in that people tend to go to a number of libraries, a small number, in order to get the documents, you can place paper versions of the Confederation debates. And we hope as well, with time, other relevant constitutional documents, the various drafts of the BNA Act, for example, put them in these libraries, and they will be available as easy and quick references. The goal, of course, is to reduce the time burden associated with getting access to accurate information.
Yeah, no, I think this is an important contribution. So this is only part of the project, though. What do you think is next for the Primary Documents project? Where do you see going after this?
Most of the action is the online, the continued scanning of documents, correcting them, hyperlinking them, making them available, causing the search speeds when people go to look for those documents to be improved. But in terms of the next thing we're going to get published, we're going to do the Charlottetown and Quebec and London conferences. Following that, it would be the Confederation debates in the other provinces, Nova Scotia and PEI and so on.
Yeah.
And after that, we're not sure, but that's getting us several years out.
Yeah, that's fantastic. Is there any thought of going into extra parliamentary sources, sort of newspapers, books, pamphlets, that sort of thing?
They do exist, often in quite an obscure form, hard to find. But yes, they were relevant. You know, the Fathers of Confederation in the 1860s, and likewise those who were promoting and advocating the 1982 constitutional package spoke publicly in other venues, and so the words they used to try and persuade the public to support them indicate that which they thought the public would find most agreeable. That means that is the publicly understood meaning of the Constitution. So their speeches are relevant. That is one thing we'll be looking for. But you also have to look elsewhere to other parliamentary debates at the time. I know with regard to the Senate, reading about the debates immediately after Confederation in the first House of Commons about how much senators would be paid and what had motivated people to become senators or legislative councillors pre-Confederation, which was largely money. That becomes very evident. So finding these kinds of documents causes a very different light to be shed. And so the larger you can make your universe, the better it is. Realistically, we'll only hit a certain, myself and my collaborators, two of whom are here today, Michael Scott and Charles Dumais, we can only do so much. We're trying to find a way, and we haven't yet figured this out, of making this more of an open source endeavor where others can come in, correct, find errors, and also point us in the direction of documents that we should have known about. Once they get into the archive, they'll then be available to the entire universe of interested people. So there'll be a natural dynamism, but searching them out initially is something that's genuinely hard to do, and we'd like to have as many members of the interested public as possible involved in that.
That's great. That's fantastic. So we shouldn't keep people from their lunches, right? So that we're not taking questions, but if you have questions about this project, I encourage you to speak to Scott and his collaborators who are here today. So thank you very much, and thank you, Scott, for this important contribution.
Thank you.